A very good afternoon and welcome once again to another episode or session of Lunch and Learn. And today we will be discussing how maintenance defaulters are blacklisted. What is meant by blacklisting? What is the procedure? Why is it done? Those are all the topics that we will be discussing and addressing today. If one looks at the webinar overview for today, we will be discussing the circumstances under which defaulters will be blacklisted on any of the 11 credit bureaus. We will also be discussing the controversy pertaining to blacklisting with making reference to the National Credit Act, the legislation that deals with blacklisting and the maintenance orders, the forms that needs to be used, Form W, as well as guidelines and the procedure for furnishing the details to the credit bureaus, how that is done, and when can defaulter's name be removed from a credit bureau. With other words, for what period of time will it be listed on the credit bureau? We will also be discussing the implications of blacklisting and as such, and how does that affect maintenance defaulters. Some logistics: if you have registered for this webinar, which we could have done free of charge on our website, www.lunchandlearn.org.za, you would also have access to the previous webinars. So if you have missed any of the previous webinars, you're most welcome to just pop on over to our website and you will have access to all the previous webinars. If you have registered for this webinar, you would have received a link bringing you to this webpage, or you could also watch online through any of our social media platforms that we utilize and we stream to. Most important, you would also have, if you have registered, you would have access to the course handout as well as the slides that we will be using during this webinar. And then, like I always say, the resource and templates tab right at the top of the page, of the web page, on the registration link. You could have access to all the documentation that we will be referring to, as well as case law. We will put that on that folder, in that folder, for you to download at your leisure, and you could use that for your future references. But without further ado, let's just start off this whole presentation about, first of all, let's start with the legislation that deals with specifically blacklisting. Now, blacklisting is a word that we use. Unfortunately, that name is stuck over the period of time. It is actually not blacklisting, because one might actually think that it might be a little bit derogatory when you say somebody is blacklisted. Whereas in effect, it is actually themselves that are that they list themselves on any of the major credit bureaus by doing something or not doing something. So it's actually not blacklisting a person, and that's actually the wrong wording to use. I tend to use the word adverse listing, which sounds better on the ear than the normal blacklisting. The acts that deal specifically with the blacklisting, let's stick with blacklisting then, would be the National Credit Act. Now, that is the act that was brought in specifically to regulate the credit bureaus. All the credit bureaus needs to register at the National Credit Regulator, which is governed by the National Credit Act, as well as the regulations that were published under the National Credit Act. The Maintenance Act also deals with certain provisions of blacklisting, where the details of the defaulter could be handed over to the credit bureaus for listing on their system that could be used for any of the credit providers. So why is blacklisting? What is the concept of blacklisting? Why is it used? What is it basically, in short? So to start off with, our South African laws are quite strict when it comes to protection of the consumer being taken advantage of by credit providers, people taking advantage of selling you things that might not be in accordance with the law. That on the one side. On the other side, it is also there. The credit bureaus are also there. The whole idea of blacklisting or having a list of defaulters or slow paying defaulters and so forth is to stabilize the economy of South Africa. so that there's a definite register where the credit providers can access. So that the main task of the credit bureaus would be to gather the information. Now, where they get that information, it's usually from the courts. It might be from people submitting the details directly to the credit bureaus, but they gather the information about a consumer's credit history. And they keep that record as up to date as possible. That is also why the Act provides that you could apply for a free credit report once a year, just to make certain that all your details are correctly reflected on that report. Now, once they have all this whole database of all the consumers where they've gathered the information from, then the credit providers, the people giving you credit, it might be a store, it might be a furniture shop or clothing shop and so forth. If they give you credit, then they can access the credit reports, and they could get the status, the credit scoring of that person applying for credit. And then they consider that data to determine the risk and also the affordability, if you will be able to pay that amount. And that is the main reason why the credit bureaus are in play at this stage in South Africa. At this stage, there is 11 credit providers or credit bureaus registered in South Africa. Some of the major ones, the biggest ones, obviously TransUnion, Experian, CompuScan, and XDS. Now, right in the beginning, initially, they started off with ITC, which is nowadays we call that the TransUnion ITC. And up until today, we refer to any form of a credit report as an ITC report. But actually, it could be done by any number of the 11 credit providers that are registered in South Africa. So what gets listed on this credit report or this credit blacklisting list that the credit providers can access? Number one is the default listings. Now, default listing is basically default data that is listed when a consumer is in default. He fails to pay a debt, usually to a bank or any of furniture shop and so forth, and they fail to respond to a letter of demand. Now, that type of default stays on the credit bureau for a period of 2 years. And they also have, most of the credit bureaus have the facility where if you are a defaulting payer and you default and you pay late on a regular basis, that might also, the behavior might also be reflected on your credit report or your credit profile. And that stays there for a period of 1 year. So if I get a credit report from somebody, I usually look at that report and they could see that for certain months, if you've paid regularly, then they give you a tick and say, right, you've paid, or if you have not paid, you might have paid late, then it would be marked as a default adverse listing on your name. The other thing that also gets listed is court judgments. That is judgments that were given in a civil court. Now, remember the criminal court does not list your credit profile. They've got nothing to do with your credit profile. That is done usually through obtaining a formal police report in order to establish if you are a criminal or not. So the credit bureaus will only list the civil court judgments. And that is when a court, a valid court, it could be the High Court, it could be the Regional Court, it could be the normal magistrate court, or even the small claims court. If they have granted a judgment, then usually for unpaid debt. Now, those type of listings remain on your credit profile for a period of 5 years, or until such time that the matter has been rescinded, or the credit provider has abandoned your judgment. They give you permission that you've settled in full and that the debt has been settled and obviously then abandoned. Another thing that also gets blacklisted or on the credit profile is the administration orders. Those are usually orders in terms of Section 74 of the Magistrate Court Act, where people apply to go under administration if their debt is less than an amount of 50,000 Rand, and then an administrator gets appointed to manage that debt on their behalf. The advantage of these type of orders are that if you are placed under administration, that you cannot incur any debt up until the administration has been paid in full. But the advantage thereof would also be that there's protection for you as the consumer, because the credit providers, the furniture shops, they cannot summons you, and they cannot attach your furniture or your property in order to be sold by public auction. That is usually what happens in the administration orders. Also, what gets listed is the sequestration orders. That is usually when a person is declared insolvent, and then a curator is appointed to manage the finances. Now, those type of judgments usually stand for 5 years, or up until a period after that for another 5 years if the person has been rehabilitated. Another thing that also gets listed on the credit profile is if a person goes under debt review. That is a voluntary application at the magistrate court in terms of Section 86, where a debt counsel is appointed, very similar to an administration order. But the advantage is that the debt counselor now can negotiate new payment arrangements of lesser amounts. So if you cannot afford an amount, then you can apply to go under debt review, and the debt counselor would then enter into negotiations with the credit providers in order to make the amounts that you have to pay less per month. That is one thing that also needs to be listed. And obviously then maintenance orders. And we'll go through the whole process of how it should be listed, when should it be listed. In practice, we find that maintenance orders are not being listed as a general rule in courts. But we'll enter into that discussion, and we'll also have a discussion with advocate raters specifically on the credit bureaus right at the end of this session. So if one looks at the legislation that deals with that in terms of Section 24(1) of the Maintenance Act, very important to note that it says, you know what, any judgment or any order or direction given by the maintenance court shall have the effect of an order or direction of that court as if it was made in a civil action. The following section 24(2), says that, you know what, that direction or that order of court would have the effect of a civil judgment of the maintenance court. So why is this important? The importance thereof is that we know that in terms of the legislation of the NCR, the National Credit Act, or the National Credit Regulator, that all judgment defaults needs to be reported and needs to be given to the credit bureaus. So here we sit with Section 24 of the Maintenance Act, where it says, you know what, it is considered to be a default, so as if it is a civil judgment. So that should be listed, even though there might be other provisions in the Maintenance Act allowing for the details to be given to the maintenance or the credit bureaus as a default, because it is a default order. That it should be listed. That is my understanding. I've spoken to a couple of colleagues, and we are all in agreement that it should not be negated. It should not be refused. In all instances where there is an order made, it is considered in terms of Section 24(2) to be the effect of a civil judgment, and that should be listed on the credit bureaus. If one also look at the provisions of Section 26(2)(a), now that was a new provision that was brought in with the Maintenance Amendment Act, and it came into force the 5th of January in 2018. This whole new section was brought in, and it says, and it reads, on the granting of an application contemplated in subsection 2 of a maintenance court, the maintenance officer or the clerk of the court, at the request of the maintenance officer, shall, notwithstanding anything to the contrary in law, in the prescribed manner and form, furnish the particulars of the person against whom a maintenance order has been made to any of the credit bureaus. And that is considered to be any business which has its objective of granting credit or is involved in the credit rating of people. So now we sit with a situation where Section 26(2)(a), 2 big A, actually provides that all this information on request of the maintenance officer needs to be given to any company that is involved with credit rating of persons, with other words, a credit bureau. So the question is, why is it not done? If one looks further, and we'll address the question, why is it not done, later on during the session. If one looks at Section 31, now Section 31 deals with people that are convicted in terms of the criminal side of defaulting on maintenance obligations. If they've been found guilty, the maintenance officer, that's now in terms of Section 31(4), the maintenance officer shall give that details through to any business that has the object of granting credit or is involved with a credit rating of persons. So after a person has been found guilty in terms of Section 31, specifically then invoking Section 31(4), then those details needs to be given through by the maintenance officer to all the credit bureaus. Is it done in practice? The answer is no. Let's come to the controversy of the blacklisting. Now, why do I say it's controversial? There's two lines of thought going around. And the one is that, yes, the defaulting or the blacklisting might motivate people for paying maintenance, because if they do not do that, then they will get blacklisted, and they will be listed on the credit bureau, and it might be very difficult for them to obtain any other future credit due to the fact that they are listed as a defaulter. That on the one side. On the other side is also true. Say, for instance, the person is listed as a slow payer or as a default payer. That would mean that his credit record has been adversely affected and that he would not qualify to apply for credit. And that is usually the argument that the fathers use, and they would say, but you know what, I'm being blacklisted now, so I cannot buy food. I cannot buy food on credit. I cannot have a Woolies card or a credit card where I can actually, or that I could actually use to pay for groceries for my child. So those are the two lines of thought. And that is why I say that it is fairly controversial when it comes to the issue of blacklisting. One of the biggest things that why we use the whole credit profile listing is also so that the credit providers, the people that give you credit, it might be a furniture shop, it might be a bank giving you a loan, that they do not engage into something that we call reckless credit. They cannot, if they do an assessment, then and they establish that you can really not afford that. If they do give you a loan, or if they do give you furniture on credit and you really cannot afford that, that would amount to reckless credit. And that the whole agreement could then be terminated. So they have to get your credit profiles and your credit details in order to do a risk assessment before they grant credit. So that is also one of the big reasons why the credit bureaus does exist. In many instances, specifically when it comes to child maintenance, the general public out there see the blacklisting as a form of punishment. And that has been going on for a very long time, where the mothers feel, you know what, they want to do everything in their power in order to punish the defaulting father if they do not pay maintenance. And that is absolutely the wrong idea. Although there is certain implications for being blacklisted, and there might be some constraints with getting credit in future, it should not be seen as a form of punishment. Enforcing the whole idea of blacklisting. If one looks at I spoke to reckless credit, and I'm just going to give you a couple of examples and just run through some legislation with regards to that. So the whole idea in terms of Regulation 2312 of the National Credit Act, once they do, or a credit provider does an affordability assessment, now that is in order to establish if you can really afford to pay back the loan or the furniture or whatever the case might be. They are under obligation to calculate the consumer's discretionary income. So they have to establish, what is your income? What do you earn? What is on your payslip? So they will probably give you or ask you for a copy of your payslip. They would also take into account all your monthly debt, all the accounts that you need to pay. And that is in order to establish, can you really afford that? And then point C, which is very, very important, and we tend to forget about Regulation 2312 of the National Credit Act. It says that if they do the affordability assessment by the credit provider, that they have to take into account maintenance obligations and other necessary expenses. So the Act is very clear that in terms of this portion of the regulations of the National Credit Act, that maintenance also needs to be declared. If you apply for credit at a furniture shop or at a bank, then you have to, the credit provider is under obligation to, in terms of Section 2312C, to take into account the maintenance obligations of that person as well. I've spoke previously about the whole idea of reckless credit, and that is dealt with in terms of Section 81(2), where it says that a credit provider must not enter into a credit agreement without first taking reasonable steps to assess the consumer's general understanding and appreciation of the risks and the costs, as well as the debt repayment history of a customer. So that is the credit report. They have to see how have you been paying your other debt in order to do a risk assessment on the current debt. And then they also have to look, the credit providers also needs to look at your existing financial means, prospects, and obligations, which obviously also includes maintenance. In terms of Section 83, declaration of reckless credit, if a court or a tribunal declares that that credit agreement was reckless, the court or the tribunal, as the case might be, can also make certain orders if the credit provider granted credit recklessly. They can then make an order setting aside all or part of the consumer's rights and obligations under that agreement, that the court might feel, you know what, this is reasonable. So they can alter the agreement. They can actually set it aside, or they can, or in full or in part, they could also suspend the force and the effect of that credit agreement. So they can stop it and they can put that on hold. Now, very interesting, Section 81(4) deals with the defenses to reckless credit. It states, and it reads, it is a complete defense to an allegation that a credit agreement is reckless. So it is a defense. If you have been granted credit, it is a defense that it was reckless credit. If the credit provider failed to fully and truthfully answer any requests for information that the credit provider may have required during this whole period of application for that. And a court or a tribunal can also determine that the consumer's failure to materially answer truthfully to these questions could have adversely affect the credit provider's attempts to make a proper assessment. That just deals with the whole concept of credit providing, and to establish if there was, in fact, reckless credit. So if one brings it back to the maintenance system now, so yes, there is an obligation that the maintenance orders needs to be listed, because it is considered to be as if it is a civil judgment, as well as in terms of Section 31. If a person has been found guilty of not paying maintenance in a criminal court, that also needs to be reported to the criminal, to the credit bureaus. And the reasons, like I've mentioned, is to do an assessment and affordability test. It could be seen as a form of punishment. It could also it could be a strong motivator that the respondent needs to comply with his maintenance obligations, otherwise he would be defaulted. So what is the process? Number one, if we look at it more holistically, and we don't see just maintenance in isolation, and we just see store credit, and we see the banks of the debt in isolation. So the first of all would be, if we bring it back to maintenance, is the listing of the details at the credit bureaus, and that would include the listing of maintenance orders as well as the defaulters of the maintenance orders. Step number two would be the affordability assessment. So once that has been listed and the credit bureaus does have that type of information, they can give that information to anyone that wants to apply for employment, for example, or for credit at a certain stage. If the respondent is in arrears or he has a maintenance order against him, that detail would be reflected on the credit profile, and that would be given to the credit provider in order to make a complete assessment that the person sitting in front of me applying for the loan or for the store credit, that they could actually afford that. So that is vitally important. That's also just to stabilize the economy with regards to that. As well as, if a person or the respondent is in default, that also needs to be listed on the profile, and that would indicate his repayment and his commitment to paying off a debt that it was forced upon him, or not forced, but was granted against him in terms of a maintenance order. Obviously, then the last portion would be the access to credit. Yes, it might be seen as a strong motivator to comply with a maintenance order, failing which you would then be adversely listed on the credit bureau. That is basically the presentation for today. I'm going to Advocate Dion Reuters is in studio with us, and then we will have a short discussion specifically when it pertains to the credit bureaus. Joining us for our discussion today is Advocate Reuters. He is the Senior Maintenance Prosecutor in the Western Cape. Dion, welcome back.
Welcome, Eugene, and welcome to our listeners.
Thank you. Dion, today we're discussing the whole issue of blacklisting, when maintenance defaulters can be blacklisted. Now, first of all, I want to bring you in our conversation with regards to the controversy of blacklisting, the negative effects that it might have on maintenance defaulters as well. Can you elaborate more on that from your side?
Okay, I'll just first speak in general. Will not touch on the Law Commission paper 157. I think that you will be able to also give our listeners some more information on the Law Commission paper 157 and what they are saying as far as the blacklisting is concerned. But in order for whenever we as maintenance officers, that is the Department of Justice's maintenance officers, or the NPA public prosecutors that are deemed maintenance officers, when they are dealing with a defaulting a respondent that is in default of a maintenance order, then one of the statutory provisions these days are that they can obviously then ask that the person be blacklisted in the sense that his details are being then handed over to the credit bureaus, and the credit bureaus will then blacklist him, meaning that he will not be able to enter into contracts or into any credit agreements with service providers that provide credit agreements. The
Okay,
negative
so
thing about it,
that would adversely affect their credit rating or their credit score.
yes, yes, that will obviously affect the credit score. And once that happens, then there are different schools of thought. And the one school of thought saying that once that happens to the respondent, then it can even affect his employment opportunities. It can even affect him being able to be the one that can provide maybe school clothing or anything else that he could have bought on credit, but obviously can't buy on credit because he's blacklisted. So there are negative consequences to blacklisting that we need to look at in order to make that final decision whether it will be in the best interest of the child. Now, obviously, the legislator, when they made this decision, it was made on the premise that the respondent will go into reckless lending, reckless credit, all of those type of things that will be negative towards the child. But there is also the school of thought that says that he could actually have contributed in a positive way by having a good credit score. So there are both good, valid points on both sides
Mhm.
against it, and those that are pro the blacklisting. Um, but it depends from which side you're sitting and talking about it.
Now, the next question would be is that it's obviously if they are in default that it needs to get listed. So, and it is only the maintenance officer. They are tasked with this to send through all the documentation and so forth to the credit bureaus. Is it
Yes.
done in courts? That's a simple question. Is it done in courts?
Um, it's not done in court. I'll be honest, and our viewers are also out there listening to this, but I haven't found that in the Section 26 attachments, when there is a civil attachment of assets, a civil attachment of emoluments, or a civil attachments of pension benefits, in any of those cases that I've ever heard that a maintenance officer asked for the blacklisting of the respondent in those specific cases. Even in the case of criminal prosecution, um, I haven't found cases in the Western Cape specifically where a public prosecutor asks for a Section 31(4) order where the accused will be blacklisted.
But so
So,
that would also have a negative effect. That would also have a negative effect because I understand the blacklisting of you know what it is basically your credit profile that gets adversely affected. But it also has to do with the reckless lending. So if the maintenance officers and or the prosecutors do not report these, then that might have, you know what, a person can then just engage into more debt and more debt, and that might amount to reckless lending. And now the National Credit Act comes into play as well,
yes.
because the person, the credit grantor, or the credit provider could then turn around and say, but you know what, it is not reckless credit because you did not divulge all the information.
Yes, yes. Unfortunately, still, Eugene, and I agree wholeheartedly with what you say. Um, it comes down to the maintenance officer informing the magistrate that you actually can do so. And even from the magistrate side, Section 26(2) is clear that he's got the judicial authority to make such a finding. Uh, but I found that in most cases, and even in the cases of presiding officers that understand the maintenance legislation, I found that there is most of them shying away from employing Section 26(2) or Section 31(4) and blacklisting people. It is unfortunately in practice what is happening. And I agree with you, it is not in the best interest of the children because it can lead to further reckless credit and all of those kind of things. So I think
Mhm.
that's something that we can maybe take up with the law commission and ask, maybe even in the regulations, that something be put that makes it almost compulsory for a court to consider it. In the same way, like in sexual offences, the court do not have a discretion when it comes to sexual offences, but the person's details will be entered. So something similar should maybe considered for the maintenance provisions in 26(2) and 31(4), where the courts will have to employ a compulsory enforcement of that provision. Else, we've got a
Yes,
piece of legislation that is not being enforced.
absolutely. I totally agree. If one looks at the provisions of the Maintenance Act, it clearly says that, you know what, once an order is granted, then that order would have the effect as if it is a civil judgment. That's
Yes,
correct. We all
yeah,
in agreement with that.
yes,
If one looks at the provisions of the National Credit Act, it says that default judgments needs to be listed.
Yes.
So why could that not be enforced in the maintenance courts to say, but you know what, as a rule, as a blanket rule, because
Yeah.
it's considered to be a civil judgment in terms of the Maintenance Act, it should
Yeah.
be listed in every case.
Yeah. Uh, well, let me put it this way: it's a part of the maintenance legislation that somehow is not being employed by maintenance officers as well as prosecutors over the last 7 years since 2015 when these provisions came in operation, 2017 when the blacklisting operations came in operation. But it is there. I am aware of it. I've done training with maintenance officers as well as prosecutors. But at the end of the day, it's for those people on the ground to enforce these pieces of legislation. And unfortunately, our public don't know about it, so they will not be able to say, but why isn't this enforced? So it's up to us as the uh, uh, activists out there to somehow
Mm.
advocate more strongly that these provisions should be enforced in our courts.
Yes, no, I totally agree with that. The last question basically is, you know what, the maintenance officers are already so overburdened with trying to get the backlog done and trying to do everything, that surely a simple administrative task like filling in a form to have that blacklisted just falls away, because you know what, there's let's face it, there's much more important tasks of the maintenance officers that needs to be attended to. I mean, if they
Yeah,
had a choice between filling in a form and assisting 60 people standing out of your door, outside of your door, out of your office, waiting to be helped, then yeah, these type of administrative tasks
yeah,
fall away or fall on to the side, and they don't get to that. And
yeah,
that seems to be the problem in the whole system of blacklisting.
yeah. I didn't want to sound insensitive, and I'm glad that you said it, so I can just concur with what you said. But it is unfortunately to tell that the maintenance clerks as well as the maintenance officers are so overburdened with other administrative tasks after seeing 10 to 16 people, couples during the day, that they actually don't get to the practical side of making sure that a emolument attachment order is served within 7 days as the Act prescribed, and to ensure that all notice to employer Form O is completed. It's a lot of administrative work for them, and except for that, then there is myself putting extra strain on them, having to compile statistics and submit those statistics to me. So it's a lot of paperwork for the clerks as well as the maintenance officers that I know sometimes they can't get to it because they've got so many other tasks that they have to deal with that they can't get to it. But you're completely correct. It is administrative task that needs to be done. Even Form W, it doesn't make provision that the magistrate sign it off. It can be done after hours, or not after hours, after the court sitting by the maintenance clerk or the maintenance officer and be submitted. There is no provision on Form W for the magistrate's signature. It's just the clerk that signs it off. So
If
it
I'm not
can be
mistaken,
done.
if I'm not mistaken, it's only the maintenance officer that is
Yes,
tasked to do that.
yes,
There's only
uh,
provision on the Form W that it
yes,
is only the signature of the maintenance officer as
yes.
the responsible person that needs to be included in the form, in the Form W.
Yes, that's it. But in most cases, whenever we say that it's the duty of the maintenance officer, the clerk do it, the clerk complete the form, the maintenance officer just put his signature and his stamp on. The same in the
Correct.
case of summons. It says that the prosecutor will issue Section 54 J605 summons, but it's not the prosecutor that do it; it's the clerk that do it, and then the prosecutor just signs it off. So there's a lot of duties that is assigned to a maintenance officer or a prosecutor that is actually being fulfilled by a clerk.
Dion, thank you so much for joining us today. That was very insightful as usual. And yeah, let's soldier on with advocating that the blacklisting actually be much more rigorously enforced, because it might have a great influence on the public out there as well. Thank you for joining us today.
Thank you, Eugene, and thank you to your viewers.
Right. Always nice to have advocate raters joining us in studio or online. Just as a matter of interest, just to indicate how severe or how serious this non-compliance of the ITC or the credit reporting actually is. These are a couple of courts that I quite frequently visit: Strand Court, Wellington, Cape Town, Stellenbosch, Knysna, and Bellville. And I have had clients in all of these courts, and I actually drew the credit profiles of the respondents in each of these cases. I just took a couple of cases that I attend to see if the respondent has been listed, and not one of these cases was there any indication that there was actually a maintenance order granted against that respondent. So this is just in order to show you the magnitude of the problems that we have in the maintenance court and the non-compliance of the legislation. And it's up to the attorneys, it's up to the public listening to advise and ask the maintenance officer, you know what, he is in default. There is an order in terms of section 26(2)(a). Please list him on the credit bureau so that we can start getting the process right and being compliant with the act. That is basically it for today, where we dealt with the issue of blacklisting. My name is Eugene Opperman. I'm a family law practitioner, have been doing so and practicing for the past 23 years, specializing mostly in maintenance, domestic violence, as well as the rights of children. Thank you so much for joining us, and also my gratitude to Erin that compiled the handout, as well as Advocate Raters for joining me for this discussion today. If you have any inquiries, please do email us on the details shown on screen, info@lunchandlearn.org.za. And we can, you know what, if you have any feedback or any comments or something that you want to share with us, please do reach out to us on the email. And we'll attend to your queries as soon as one of the attorneys from our offices are available. We hope to see you next week, same time, same place, for another exciting Lunch and Learn. Same time, same place. Have a fantastic afternoon further.